Good morning. Please be seated. We are here for oral arguments in cause number CR 15-0302, State of Arizona versus Jodi Arias. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 30 minutes for their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs, we have conferenced this case, we are familiar with the facts and the evidence presented at trial. Please take that into account when formulating your presentation. At this point, counsel, are you ready?
Yes, Your Honor.
Please proceed.
Good morning. May it please the court? My name is Corey Engel, and along with co-counsel Peg Green, I represent the appellant in this case, Jodi Arias. This court should reverse Ms. Arias' conviction because it was obtained during an unfair trial. The prosecutor in this case engaged in pronounced and persistent misconduct which permeated all stages of the trial. His misconduct began as early as jury selection and continued as late as his closing arguments.
If you had to identify the top 3 acts that you believe most impacted the trial, because in your brief you've alleged multiple, what would your top 3 be?
The very worst act of misconduct that Mr. Martinez committed was, and this sounds as if I'm avoiding the court's question, but it was the cumulative misconduct, because that misconduct worked together to build on itself across the entire trial. He had a theme that he was working from and a goal he was working towards, and he used his misconduct with each one of the witnesses to keep working towards that goal in his closing argument, and then he capitalized on it at that point. So it truly is the cumulative error in this case, the synergistic effect between the different kinds of misconduct that was committed that is the worst misconduct here.
Define what you refer to as the theme. You said he had a theme to work on. I want to hear what your definition of the theme is.
The theme in this case was nobody in this trial is telling you the truth or should be trusted except for me. I am the only person here who is above board, who is ethical. He made every one of the defense experts out to be a person who had a relationship with Arias and who had been hiding evidence and who had changed evidence based on their feelings for Arias. He alleged that the defense was fabricating their case, and in his closing argument, he hit on that theme again. And he even went so far as to argue that everything that came from one of the witnesses was nothing but contaminated filth. So the theme in this case was, everybody else you should ignore except for me, and not because of the evidence, but because of the prejudice and sympathy that he attempted to invoke in the jury against those witnesses.
There were suggestions, there were assertions, I believe, that experts had emotional attachment to the defendant. Is that correct?
That was certainly Mr. Martinez's accusation.
Give me your best assessment of the premise for that.
Mr. Martinez's premise for that?
The assertion is you have feelings for her. Wasn't that the assertion? Give me the state's basis for that.
Well, the state's basis for that was a misleading cross-examination in which he used the fact that an expert who routinely, like a psychiatrist or a psychologist who routinely meets with people who are in jail and sends them books, that simple act that he commits with every person that he meets with was enough to assume an actual relationship and feelings for this particular defendant.
We're talking about Dr. Stewart specifically, correct?
Dr. Samuels? I'm sorry.
Samuels, sorry, wrong S name. Okay, so Dr. Samuels specifically, and when we look at the cross-examination of Dr. Samuels, the prosecutor does go into a lot of depth about that being the giving of a gift. Other than that single giving of the book, was there anything else evidentiary-wise to support his proposition that Dr. Samuels had developed feelings for Miss Arias?
Other than his own assertions, no. That was it. He did attempt to get Dr. Samuels to define the definition of compassion and whether he felt sorry for Miss Arias. And the doctor repeatedly said, no, I don't feel sorry for Miss Arias. And then later on in another portion of the case, he asked a misleading question of the doctor where he said, well, didn't you earlier during your testimony use the word sorry? And while the doctor did use the word sorry, it was only in reference to saying, that's not how I feel about Miss Arias. But the way that Mr. Martinez was able to frame that question made it a very misleading cross-examination. It made it seem as if the doctor was trying to hide something he'd said earlier.
Okay, so we're going back to your top three. We've got cumulative misconduct. The theme of the case, everyone is a liar here but me. What would be your number third?
It would be the accusations of the experts having relationships with Arias, and the accusation that they were hiding evidence, the accusation that they had changed information on the testing forms, and the way he tied those together across both experts, to the point that the jury was even asking questions about whether or not the second expert had feelings for Arias, and asking the second expert if it was possible that the defense was hiding evidence from her in order to get a better opinion from her. So that's the way in which you can see that he built on his misconduct from one witness to the next witness to his closing argument. They wove together to tell one story. So that would be my second or third, however you want to count that, worst examples.
If that's your second, do you have a third?
I think that the persistence and improper questioning by itself is enough to warrant reversal on its own, as the Poole court found in that case, based solely on improper questioning. They said that reversal was warranted. And I believe the kind of improper questioning we have here, the amount, the type, the persistence in it, is much greater even than was found in Poole.
Counsel, let's assume we agree with you on all the points you've made thus far. How precisely was the defendant denied a fair trial?
Arizona sets forth the test for what a fair trial is when cumulative error renders a trial unfair, and when prosecutorial misconduct mandates a reversal, as when that misconduct is so persistent and pervasive that it permeates a trial. And that's State versus Hughes. Hughes is adopting or setting forth that test based on the United States Supreme Court case of Donnelly, which talks about when due process has been violated, when a trial has been so infected with misconduct that it violates the due process clause. So that's one of the basis from which the Hughes decision comes. The second is that it's adopting the language from Berger, which is also a U.S. Supreme Court case, on pronounced and persistent misconduct that permeates the entire trial. That's the test. That's the four corners of when do we have to reverse for prosecutorial misconduct.
So are you suggesting that prejudice is presumed here under the third prong of Escalante?
Yes, I am.
I mean, then aren't you also saying in that same, by drawing that conclusion, aren't you saying that there's a structural error?
Yes.
But, okay, let's talk about it. Share with me some of the examples that the Arizona courts or even the United States Supreme Court have found to be structural error.
I don't have specific cases where I can tell you this is what the court found.
Like complete denial of right to counsel.
Right. I know that the definition of structural error involves the kind of error which makes the actual ability to determine guilt and innocence. It affects the overall mechanism by which we determine guilt or innocence and makes that unreliable. And it's the very unreliability of the trial because of the amount of the misconduct that makes this the kind of case where you do presume prejudice. And that's because if you consider the kind of error that we're talking about in Escalante, that third kind of error, where the error is so egregious that a defendant could not possibly have received a fair trial, that language of that test matches the language that Hughes adopts from Donnelly and Berger, or error which so infects the trial with unfairness that it violates due process.
Do we ignore the Arizona case law that talks about balancing the overwhelming evidence of guilt against the prosecutorial misconduct? I mean, we have a whole line of case law that says if there's overwhelming evidence of guilt, we are not to overturn a conviction based on the conduct of the state.
No, you absolutely should not ignore those cases, but it's very important to differentiate between a case where we're reviewing for individual error, which is reversible on its own, and for which the standard is first you prove that there is error, and second you prove that that's prejudicial. And whether or not it's prejudicial is dependent on whether or not the defense objected, so to use harmless error or fundamental error at that point. Because we're not specifically at this point arguing under the individual error standard, we're asking the court to make a finding under the cumulative error test. The cases which deal with overwhelming evidence of guilt are the ones that are addressing whether or not prejudice has been proven after error occurred. But because the cumulative error test, when proven, includes both the error and the prejudice as Escalante, that sort of an error proves both error and prejudice, and a defendant is not required under that third prong to separately prove prejudice after they've proven that their trial was rendered unfair. It's not that we're asking the court to ignore that line of cases. We're asking the court to proceed under a different avenue of cases, a different branch of consideration. And the avenue that we're under, we would not separately prove error from prejudice. Once you've met the cumulative error test, there isn't an additional review for fundamental or harmless error.
Are you aware of any case, either Arizona or otherwise, that has held, notwithstanding the overwhelming evidence in this case, we conclude, or we hereby reverse the conviction based on pervasive misconduct, cumulative misconduct, intentional misconduct?
Yeah, Arizona cases on prosecutorial misconduct where they've actually reversed, it's a very small body of law. There are about 4 cases.
Hughes, Poole, and maybe a couple others.
Minutes and the recent case from Division 2 in Dansdale. As far as I could determine, Hughes is the only case where there is an affirmative finding of cumulative error in Arizona. And what we learned from Hughes and looking at what the Hughes court did is that after they found cumulative error, they did not apply harmless error or fundamental error review after they found cumulative error. Now, they did talk about harmless error, and there were 4 sections of the opinion where they started analysis of whether or not the defendant objected to this kind of error and whether or not there was overwhelming evidence of guilt on those particular categories. But then the court moved away from those categories, found that cumulative error existed, and then the very last sentence was, we don't need to decide which ones of the individual errors are reversible on their own because we find that cumulative error exists here. And so we're essentially asking the court to engage in the same sort of analysis. Rather than doing the individual analysis first and then moving on to cumulative error, we're asking the court to find the cumulative error first because it's so persistent and pervasive in this case. Just as a matter of judicial efficiency, it's easier to come from that direction than to work the other way through each example.
I'd like you to move on a bit to the publicity aspect of this case. And I'd like you to address the court's role in making sure that publicity is appropriate for a courtroom setting, and also what steps should the court take in ensuring that publicity doesn't create that carnival-like atmosphere that we talk about?
The defense requested that the court sequester this jury. That would have been the best way to minimize the worst effect of the carnival-like atmosphere. It may still have continued, and you still would have seen the effect that this atmosphere had on, for instance, the witnesses who were being harassed and threatened, or the defense attorneys who were receiving death threats and were being followed from court to dinner at night and having their photos taken. The court doesn't have the ability to control what the public does, but they have the ability to control the things that are feeding the lynch mob mentality that was happening with the public. They can control whether or not the jury is impacted by that by sequestering the jury if it's necessary.
When we talk about the impact on the jury, Judge Stevens was quite careful to questioned them often about their exposure to the media, etc. And they all assured the judge that they could remain fair and impartial. When we look at what defense counsel did, Judge Stevens asked, do you want the cameras out of the courtroom? Defense counsel said no. There is one instance in over 60 days of the guilt phase of this where defense counsel said, yes, we'd like the cameras out of the courtroom. And the judge said, can you put that request in writing? Which defense counsel did not do. So given that, how do we address the challenges you've brought up regarding the carnival-like atmosphere of this case that you've alleged in your briefing?
Well, separately and apart from asking for relief purely based on the publicity portion of the case, we're asking also that the court consider the way in which the prosecutor's behavior fed into and capitalized on that publicity.
If we consider the prosecutor's behavior in churning this publicity, don't we also have to look at Ms. Arias's engagement with the media? Because in my review of the record, it appears that she began courting the media.
After Ms. Arias was appointed counsel, I believe there was one interview that she gave, and that interview was on the day that she found out she was eligible for the death penalty. So, and she certainly wasn't standing on the courthouse steps signing autographs with fans or taking photos with fans.
No, she was giving an individual interview in a private interview session with members of the media.
And it's not to say that there isn't some consideration of that. Obviously there should be.
Counsel, you say some consideration. Didn't the defense approach the judge at one point and say that they were struggling because it appeared Ms. Arias was attempting to try her case in the media?
You know, I don't remember that specific statement, but I take the court at your word that that's what. I just don't have a memory of that. But assuming that was true,
wasn't it pervasive at the start with Ms. Arias, getting out in front of the media as much as she could?
There were 3 interviews given, 2 of which were before she had counsel, and 1 of which was afterwards, and was the day that she found out she was eligible for the death penalty. So to say that Ms. Arias was the one that was courting the media, I don't know that I don't believe that the record supports that. I believe that.
For a moment, though.
Yes.
Ms. Arias also voluntarily gave an interview after a verdict was returned, did she not?
Yes, that was the day that they found out that the.
Okay,
yes,
so we're talking about, and I just want to clarify that happened at the end. So we have 2 before and 1 at the end. So it doesn't appear that she ever gave up on her desire to get her story out.
I would disagree with the court respectfully on that, because given the amount of media attention and the amount of the fact that there were no interviews during the trial shows that there was some control over whether or not Ms. Arias was courting the media. If Ms. Arias really wanted to be in the media, she could have been doing interviews nonstop. But what we had was a definite lull as soon as she had counsel, which there's nothing in the record to support this, but as a defense attorney, my understanding would be that the very first thing you do is explain to your client.
How, as an appellate court, are we supposed to parse out which party's actions contributed to the interest in this case, leading to what you allege was a carnival-like atmosphere?
Well, there's only one party in it when we're talking about the difference between Ms. Arias and Mr. Martinez that has an ethical duty not to try his case in the media. And that's not Ms. Arias. That's Mr. Martinez.
Agreed. But we'll put the ethical issues aside and we'll discuss those in the context of prosecutorial misconduct. Let's talk about when you make a challenge about publicity.
Right.
How do we determine from a cold record who was at fault for churning the publicity bandwagon, so to speak?
I'm not sure that the court, there's any mathematical formula that the court could use or apply to say, well, because Mr. Martinez did this many acts in front of the public and Ms. Arias did this many acts in front of the public, we can therefore say it's a balance. What the court has to look at is who had the greater ethical duty, who benefited from the media attention. Because
Counsel, isn't it kind of ludicrous to sit down and say that we can look at the conduct of Ms. Arias and we can look at the conduct of Mr. Martinez and apply no standard, but just simply assume
Oh, I'm not,
that the one did greater damage than the other when she's out there telling the story as widely as he's doing what he's doing in the courtroom?
again, I would disagree that Ms. Arias was as widely as Mr. Martinez spreading her story. I disagree that she was doing so during the trial. She did not. Mr. Martinez did. Ms. Arias did not tell the court when the court questioned about the unfairness of signing autographs on the courthouse steps, as Mr. Martinez did. His response was, it wouldn't matter even if the jury did see it, and it's not misconduct if I do it outside the courtroom.
Understood.
Ms. Arias at least responded to, I'm assuming based on when the interview stopped, responded to her advice of counsel to stop doing interviews. And I wanted to go back to a point that the court made earlier about whether or not we can trust that the jurors didn't, when the court was asking the jurors whether or not they had actually been affected by the media in this case. And given that they said numerous times that they hadn't, whether we should trust that. First of all, we know that there is case law that indicates that at some point you don't necessarily keep assuming that the jurors are being accurate, that they have had no impact by the media in the case. And you especially shouldn't on this record when you have at least one juror who, when the court was considering whether or not they would strike her the next day, she went home. She came back in tears the next day because when she got home, her husband had let her know that based on the news coverage, she might be struck. Then the court asked her, but you're not supposed to be watching the news. Oh, I'm not watching the news. Nobody's telling me about the news. So we don't always get a precisely accurate response from jurors who know that if they say that they are watching the news or they have been impacted, that they're going to be struck from a jury that they've been sitting on for quite a long time and don't want to be struck from. And that's one specific example that we actually have in the record, not an assumption that I would ask the court to make, but an actual fact in the record to support the fact that the jurors were not accurately reporting whether they were affected.
That juror had additional issues that were not disclosed during voir
Right.
dire, and when we look at what the substance of her testimony was, it was questionable to begin with. So striking her was the appropriate course of action for the court, agreed?
Absolutely.
And did that not cure the issue?
Yes, and I wasn't bringing up that particular juror to argue that there's some sort of reversible error with regard to that, but only in that is an example of the way in which jurors believe that they are truthfully and accurately portraying to the court that they've not been impacted by the news or the media or anything that's happening outside the courtroom, but when in fact they are, and that they're answering the question so that they can stay on the jury.
If we were to accept that premise, would it not undermine our entire jury system?
If you did it in an average case where a jury wasn't asked as many times as this jury was, whether or not they could still be fair and impartial. If you did it in a case where this jury was actually escorted back and forth from the courtroom by SWAT members. So the idea that this is an extreme case, this would be a rare finding from a court, not necessarily one that would apply to every single case of which the court was bringing up just now.
When we look at our tradition
Yes.
of relying on citizens of this country to sit in judgment of other citizens, and we rely on them to tell the truth when questioned.
Right.
If we were to say, we don't trust you here, doesn't that mean we can't trust them at all?
Case law has come to that conclusion that at a certain point when jurors have been asked this many times, or whatever the standard is in the case, and I believe it was Irwin versus Dowd, that there comes a point at which you stop assuming that the jurors aren't affected by the media and are not affected by the media and the circus-like atmosphere, even though they're reporting. And I'm not saying that the jurors are lying. I'm saying that they're doing their best to report, but their report isn't necessarily accurate. The juror that I'm talking about, when the court said, but how did your husband even know which case you were on, was flummoxed. It was very clear that the juror didn't believe that she violated the court's orders in any way, and the court didn't make a finding of that, but she definitely was receiving information.
And she was removed from those that sat in judgment of Ms. Arias.
Right.
So is that not the remedy that should have occurred?
It is the remedy that should have occurred, but when the court is weighing whether or not the jury was affected by the media, the sole basis of the court determining that can't be that the jurors told us that they were not affected. Because if the media and the circus-like atmosphere is bad enough and continues for often enough, and the jurors are impacted in large ways and small ways, large ways like being escorted by SWAT team members, small ways by being asked 15 times, can you still be fair? Have you seen anything? Are you watching the news? Did you see anything outside the courtroom?
So is 14 times too much? Is 13 times too much? Is 5 times too much? I mean, you're asking us to enter an order that would affect the propriety of the tradition of our country of using jurors to determine guilt or innocence. That's a slippery slope. Would you agree?
I agree that it could be, but it's always based on the facts of a particular case. And when courts make a ruling, it's always tied to this case's facts. And this case, the facts are fairly extraordinary. I don't believe that the court is going to be setting a precedent that is going to apply to every jury in Maricopa County. We don't have this kind of media coverage or this sort of a media circus in every single case. And hopefully, in the next case, the court will impose some restraints earlier on in the process.
Let's talk about that.
Okay.
Okay. So, publicity was an issue. I want to know what you think the court failed to do in reining in, one, the media or the publicity, and in this developing technological age where we're tweeting, we're Snapchatting, we're doing all of this stuff. So it's not even the traditional media, it's anyone has access to this information. What could the court do, and what did it fail to do? And also, what did the court do and what did the court fail to do in regard to prosecutorial misconduct? And you have 4 minutes, so I just want to get that out there.
Okay. With regard to Mr. Martinez and what the court failed to do, the court failed to enforce its own orders, its own rulings against Mr. Martinez.
Was it too tolerant, simply too tolerant?
Yes. I mean, the case law indicates the courts cannot be merely a passive observer in the trial process. And the best way to stop guerrilla warfare in a courtroom is for a strong judge to issue rulings and enforce them.
So she can't just tell him 100 times to back off.
Right. And she also can't sustain an objection to something he's said, have him come back and ask the exact same question, and then overrule the objection that she gets from the defense saying, Your Honor, he's doing it again, which is what happened here. So the court needs to also, when a prosecutor is being this persistently pervasive in their misconduct, needs to admonish the prosecutor that they're in danger of causing a mistrial, which the court actually did here at one point regarding speaking objections, but Mr. Martinez then engaged in 26 more speaking objections afterwards. So at some point, the court has to be willing to and has to let the prosecutor know that they are willing to declare a mistrial if the prosecutor is endangering the right to a fair trial, and that's simply not what happened here. I'd like to reserve the rest of my time, if I may.
Thank you, counsel. Good morning.
Good morning, Your Honors. Terry Chris for the state of Arizona. State versus Johnson from our Arizona Supreme Court says, to prevail in a claim of prosecutorial misconduct, a defendant must demonstrate that the prosecutor's misconduct so infected the trial with unfairness as to violate due process.
Mr. Chris, before we get started, I'm looking at page 99 of your brief. Let's get started there. The state submitted a brief, and at the top of the heading says, the prosecutor did not engage in misconduct. Do you stand by that statement?
Yes, Your Honor. Misconduct as defined as the violation of due process by these cases. So we have both the state Supreme Court.
So you believe it only is misconduct if it affects a defendant's right to a fair trial, due process. That's the only time we should consider misconduct.
Yes, although I think we might be discussing semantics here. What we're really talking about is that the due process standard requires a defendant to show that the prosecutor did something improper, and that impropriety infected the trial by making it impossible for the jury to issue a fair and impartial verdict.
What authorities suggest that we leave it out when you're discussing individual instances of misconduct? Why would we even look at due process?
The authority
What
would
authorities suggest that?
Donnelly and Darden from the U.S. Supreme Court. So,
Arizona, and let's talk about Arizona law.
So Arizona law is admittedly a bit inconsistent on this question because When Arizona authority talks about prosecutorial misconduct, almost every case opens with the due process standard. And then some of the cases talk about individual instances, but then ultimately reviews them for the cumulative standard.
Then, Mr.
So,
Chris, let's go back. If we take a more narrow definition of prosecutorial misconduct, okay, and we say conduct engaged by the prosecutor that violates the rules of evidence and ethics, under that definition, do you believe that your statement that the prosecutor in this case did not engage in misconduct is true?
we would argue that the prosecutor may have done some things that violated rules occasionally, and the court sustained objections when that was appropriate.
When we say occasionally, are we talking once, twice?
I don't have a
100
number.
times?
I don't have a number for you, but I would say in a
What
6-month
about
trial.
the fact that there was 39 objections sustained on argumentative questions to the defendant? 39 times.
39 in context of the
No,
6-month-long
but
trial.
sustained, though. Not just objections made, sustained.
In the,
How does that not register to the prosecutor's mind that something may be off in my questions?
well, perhaps it should. Ultimately, the mental state of the prosecutor is not relevant to this analysis. The defense is not raising a Poole claim here. It is only raising a claim of prosecutorial misconduct. And the intentionality of the prosecutor simply isn't relevant to whether the jury was prejudiced.
So if we accept your proposition, let's go on to question 11 in the questions we set out for you. What steps, if any, might a court take to constrain a prosecutor's conduct inside the courtroom during the proceedings if there is overwhelming evidence of guilt? What is a court to do if a prosecutor becomes, rather than the minister of justice and the finder of truth, and becomes an actor on a stage who is loving publicity instead of doing the job of getting to justice?
I think there are several things the court can do. The court can do what this court did and sustain objections when appropriate. The court can admonish the prosecutor. Ultimately, if the court finds that the trial is not prejudiced, but the prosecutor's conduct was out of line, it can do the same things an appellate court can do. State versus Valdez tells us exactly what this court should do in that circumstance, which is to affirm the conviction and then to refer the prosecutor to bar proceedings if that's appropriate. But what the court can't do is declare a mistrial when there's no prejudice to the jury.
Okay, so let's go to a statement made by the prosecutor at the bench on April 2nd, 2013. They're in a discussion, and the judge is there, Ms. Willamont is there, and Mr. Martinez basically insults Ms. Willamont, talking about if he were married to her, which is an inappropriate basis to object, to discuss. It also calls into account her gender, which is inappropriate, and he also used an expletive, which would, in my experience, get you expelled from most courtrooms. How do you even defend that kind of conduct in this context of a death penalty case?
I don't think that comment was appropriate in the slightest. However, the jury did not hear it. And ultimately, what this court is deciding is whether the trial was fair.
So it's only about whether or not the jury hears it.
Yes.
So when a prosecutor walks up to the bench and engages in vulgarity to a judge, that's okay.
It's
That's
not
okay, as long as he says it just loud enough that it doesn't get all the way to the jury box.
No, it's not okay at all. It's just a question of remedies, and the remedy is not to reverse the conviction. That's what every case on the subject has said. We don't punish prosecutors by reversing convictions.
So, Mr. Chris, what do we do when somebody engages in a persistent course of shenanigans that goes flying in the face of the rules of ethics and in the face of the rules of evidence? Would you agree with me that unless you have a strong basis in evidence to support an inference that one of the expert witnesses is having an inappropriate relationship with the defendant, unless you have a basis in actual fact, that inference is inappropriate and in violation of the rules?
If that's what occurred, I would agree, but that's not how I read the record.
Tell me how you read the record, because I'd like to understand.
So when he uses the word feelings, he's not referring to some kind of romantic attachment. He's referring to Dr. Samuel's discussion about compassion. And this comes from an earlier discussion where Dr. Samuels had done several things that later the state's expert was going to come up and say were inappropriate. There's a line between therapeutic treatment and evaluation.
Show us that in the record.
Show us that in the record.
Where did your people come up and say, oh, no, that was good, that was perfect?
Well, what our expert did was our expert came up later and said that an evaluator ought not to cross the line to become a therapist. And several of the things that Dr. Samuels had done were on the wrong side of that line, such as the gift of the book, such as having an extended interview session, and also the rescoring of one of the tests. And so when the prosecutor asked Dr. Samuels about it, Dr. Samuels' explanation was that he thought that Ms. Arias was suicidal, even though he never reported that to anyone, and that he felt compassion for her. And they may have quibbled over semantics about whether sorry or compassion was the right word for that. But ultimately, Dr. Samuels did say that he felt some sort of feeling that compelled him to do it, and the prosecutor thought that feeling could compromise the objectivity of his
He
conclusions.
also said it was common practice to provide self-help books that the prosecutor continued to categorize as give gifts to Miss Arias, which a self-help book when you are a psychiatrist is not the same as giving a gift in the traditional sense of what we would call a gift. Would you at least agree with that?
Not entirely, Your Honor, because again, the question isn't simply did he act as a proper psychologist, it's did he cross the line from being an evaluator to being a therapist. And that's what Dr. DeMarte talks about when she comes up for the state.
But the prosecutor insinuated it was some sort of inappropriate relationship outside of the context of, I feel sorry for you. And I've read the record, and that's the way I read the cold record. I can't imagine what it was like in the courtroom. So tell me, was that inappropriate if in fact that's the way I'm reading it?
No, in light of the U.S. Supreme Court's decision in Donnelly. Donnelly tells us that we ought not to assume that a prosecutor's comments have the most objectionable meaning if there are multiple ways to read it. And here, I think it's
So
entirely...
You can just get close to the line and not say the words that you're having a sexual relationship or you want to have a sexual relationship. You can just say a relationship, even though a juror specifically asked a question. I mean, I think that our reading of the record, counsel, is different, is much different than yours. So I think the question is, let's assume that it was inappropriate. That doesn't change your mind at all about whether that could qualify as prosecutorial misconduct.
Ultimately, I think we're looking at whether the jury was prejudiced. And so, assuming for the sake of argument, and I'm not conceding that that's the reading of the record because it's not how I read the record, but assuming for the sake of argument that that were the only way to read the record, it would be improper without an evidentiary basis. However, I think all of the reasons why there wasn't prejudice in this case would apply. For one, the trial court made multiple findings throughout the case at various times when there were objections. And then at the end of the case, that nothing the prosecutor did amounted to the sort of prejudice that would merit a mistrial.
So just let me explore that a little further. So there's probably, what, half a dozen times at least that motions for mistrial were made?
Yes.
And denied?
Correct.
What significance does that have for us?
I think...
Does that mean that the trial, are we to presume the trial court was correct every time?
We defer to the trial court's findings of facts and the demeanor of witnesses and the prosecutor and the jury. State versus Halsey tells us that when a trial court finds that the prosecutor's actions were not prejudicial, that is meriting deference. So I think we should consider that. I think we also consider the curative instructions and the jury instructions in this case, that the lawyer's comments are not evidence and the jury should only base their decision on the evidence and not sympathy or other kinds of emotional issues. And then finally, there is the overwhelming evidence of guilt. I don't think we can look past the fact that the evidence of guilt is very strong in this case.
That's on that point. Can you cite any authority from Arizona, or you can cite to other jurisdictions if you have some, what authority supports affirming conviction when there's been intentional, pervasive misconduct based on overwhelming evidence? In other words, let me explain that more carefully. When there is overwhelming evidence, what authority supports affirming the conviction when there's been intentional, pervasive misconduct in the case?
Darden versus Wainwright from the United States Supreme Court references overwhelming evidence. State versus Newell from our Supreme Court.
References it, but did it affirm and said that the prosecutor in fact engaged in intensive, pervasive misconduct, but nonetheless the court upheld the conviction? That's my question.
State versus Newell, State versus Godot, and Darden all affirm ultimately upon finding that the prosecutor engaged in improper behavior, but in light of the overwhelming evidence, they would affirm. I would, though, add that the intentionality.
Improper behavior, are you saying that improper behavior was intentional pervasive misconduct?
Intentionality is not something we consider at the stage of the analysis.
What stage of the analysis are we at?
We're at step one of Poole. I mean, not because we're in a Poole claim, but ultimately the question here is just should there be reversal on prosecutorial misconduct? And the intentionality of the prosecutor is not part of that analysis.
And I understand your argument that you've raised between the difference between Poole and Hughes, and that Poole is solely, it should be confined to a double jeopardy case. But that's not how the Supreme Court and our court have viewed it. Now, maybe we're wrong on that, but I think under existing law, we do look at intentionality.
Well, I'm not sure the law is that clear. Part of the problem is we also have, from a variety of Arizona Supreme Court cases, even as recently as Halsey, statements about how we don't reverse convictions to punish the prosecutor. The only relevant
Understood. I'm just asking for a case that actually finds intentional pervasive misconduct and still affirms the conviction. I think what I'm taking for your comments is there's not one, and we would be the first to say so if we're to affirm the conviction here.
I stand on the cases I cited, State versus Godot, State versus Newell, Darden versus Wainwright, all found that overwhelming evidence was the reason to affirm in light of the prosecutor's improper conduct. But the other thing about the intentionality is if that's really the test, then Poole doesn't mean anything, because every reversal for prosecutorial misconduct, assuming that all misconduct had to be intentional, would mean that double jeopardy would attach with every reversal.
In light of what opposing counsel said, is that really a concern? When she pointed to perhaps four cases in the history of Arizona that have actually reversed a conviction for prosecutorial misconduct?
Well, I'm not sure I would say it's a concern. It's just Poole is binding precedent, and it has to mean something. And if the Poole tests were illusory because only one of the three prongs actually did work, then I think that would suggest that that's not a correct reading of Arizona case law.
And I like that we're talking about the prong, and I'm going to go back to no prosecutorial misconduct occurred. You understand that's a two-prong, did it occur? And the second prong is, did it affect the trial? So again, you keep telling us that prosecutorial misconduct did not occur because it did not affect fundamental rights. What I'm telling you is, did prosecutorial misconduct occur? Did the prosecutor in this case engage in conduct that violated his ethical duties, his duties of candor to the court, and his professional conduct?
There were times when the prosecutor did things that would meet that definition. I would first say that the violation of ethical duties doesn't necessarily mean that he committed misconduct for purposes of the due process standard. They're actually separate tests. And also, ultimately, what matters is the prejudice of the jury. So even if the prosecutor did something improper, but it wasn't prejudicial, then it ultimately wouldn't result in reversal. So
Does it then just become an ethical problem that needs to be addressed?
Yes, Your Honor.
So that's where we're left with that?
Yes, that is what the tests say. That Halsey and Lynch and a variety of other cases are clear that we don't reverse convictions to punish prosecutors.
So going into the case, the prosecutor knows that. I mean, because the prosecutor knows what his or her evidence is going into the case. So they have free reign, absolutely free reign in a case, because there's nothing an appellate court can do to reverse that conviction. And not that we would want to, of course not. That would be detrimental to the victims, to the society, to the judicial system. But what prevents a prosecutor? What is this? What measures are we looking at to stop a prosecutor from thinking in the back of his or her mind that they can engage in this type of behavior, and no matter what happens, I'm not going to get reversed?
Disciplinary sanctions are the appropriate remedy for that. I think
a bar complaint.
Correct. I think it's important to keep in mind, especially in a case with overwhelming evidence, that we have a conviction, and if we think, for purposes of this question, and then of course it's also our argument, that the jury was not prejudiced, then ultimately the trial was fair. And so if the prosecutor does improper things that nonetheless result in a fair trial, then it would be a greater miscarriage of justice to reverse the conviction and let a person go free who was convicted by overwhelming and fair process.
So I want to make sure, and I'm going to pin you down on this. You agree that improper conduct was engaged in on the part of the prosecutor in this case?
There are some instances, yes. Not as many as the defense argues, and none that resulted in jury prejudice.
Can I
All
ask, not as many, I guess I'm going to say, not as many acts or not as many acts in on multiple occasions? I mean, there are dozens and dozens and dozens of objections that were sustained on the same issue. How do we deal with that? Is that cumulative?
Well, if the objection's sustained, then often the answer was never given in many of these cases. And there was a jury instruction at the close of trial that the jury should not consider questions or answers that resulted from sustained objections. It didn't need to be the case that the court struck an answer because the jury instruction actually covered both question and answer. We presume juries followed those instructions. And so, especially in the case of sustained objections, I think we have more confidence that we wouldn't have prejudice.
Let's move on to the next topic because we're going to run out of time here. When we talk about publicity inside and outside the courtroom, the prosecutor maintained that anything that happened outside the courtroom was not, in fact, misconduct. And based on the definition I've given you of misconduct, do you agree or disagree with this statement?
I disagree with that. The ethics rules are clear, actually, that the prosecutor has certain ethical obligations outside the courtroom to not make prejudicial statements to the media, and the trial court certainly could enforce those rules and admonish the prosecutor if he did something out of line. Ultimately, in this case, though, that didn't occur. The worst that the defense cites here is the prosecutor takes some photos and signs some autographs with people. I'm not even sure if those violate the ethical rules, and more importantly, the trial court held an evidentiary hearing on the question, took witness testimony, and concluded the jurors knew nothing about it. So really, in the end, it didn't contribute to any kind of prejudice for either the prosecutorial misconduct analysis or the Shepard trial publicity analysis.
So let's talk about the publicity and the fact that there was a request for sequestration. It was denied. There was at one point a request to remove the cameras from the courtroom. The publicity in this case, from whatever source, led to defense witnesses being threatened, and it's death threats, quite frankly. Counsel for the defendant being threatened. To work in that kind of a environment where not only are you worried that you're doing a good job, you're also worried for your own physical safety. What can a court do at this point?
What could the court? Well, the court could have. I think the real ultimate question here is much like the prosecutorial misconduct question, was the jury affected? And so while these things are unfortunate, they're certainly not things that anyone wants to have happen, they're not a basis for reversal.
So death threats. We should advise in certain cases that your life may be threatened and there's really nothing we can do about that. So what, just suck it up?
I think that the court could try to order more protection for someone perhaps, but at the end of the day, the court can't control everyone outside of its chambers. And while we certainly are not approving or supporting anything of that sort, but it's just not relevant to the Shepard analysis because what we're looking at the end of the day is whether we can rely on the jury to give a fair and impartial verdict. And these things have not, the defense has not linked them in any way to the jury's deliberations.
So the Shepard analysis just simply doesn't fit this situation.
Well, there is no case that does, and that's, again, authority for affirmance here. Ultimately, the defense bears the burden, much like a prosecutorial misconduct analysis, where the defense has the burden to show both impropriety and prejudice. We don't presume prejudice in that context. Here, the defense has the burden to show that trial publicity was so pervasive that we simply just can't believe the jurors' answers when they tell us they're not considering it. That's not what happened here. If you actually look at the very few, and I should add, Arizona's never reversed a case on this so far as I can find, and the U.S. Supreme Court hasn't done so in over 50 years. So if you go back to the very small handful of cases where the U.S. Supreme Court has actually reversed on a trial publicity claim, the order of magnitude of the coverage and the inflammatory nature and inaccurate nature was so much worse than anything that occurred here. So Shepard, for instance, you have a judge who refuses to admonish the jury to not consider these things. And you also have inflammatory accounts of perhaps the defendant is having an illicit affair with an inmate, the presumption of guilt, all sorts of things going on, and that's just not present in this case.
So from the state's perspective, Did the court do anything, or could the court have done anything differently that would have reined in the carnival-like atmosphere that's alleged by your opponent?
I'm not sure what more the court could have done, really. The court could have admonished people in the courtroom, but ultimately the courtroom itself is fairly serene. Most of what the defendant argues about here is conduct by third parties from the internet and other places after the trial is concluded for the day, and those people aren't in any place where the court can do much about them.
But how was that all enhanced by autograph sessions and personal photograph sessions and all of the let's go out and mix with the public, because after all, anything I do outside is not misconduct?
Not much, I think. For one,
There
there's
was
only...
no banging, there was no banging the drum going on out there? There was no saying, I'm one of you?
No, I don't. I mean, there was one instance where he took photos and signed autographs, and we don't have any more than the record than that. And the defense hasn't really linked that up to anything that the unfortunate spectators have done in this case to threaten. Certainly, the prosecutor never called for anyone to threaten or intimidate witnesses. There's no instance of any kind of intentionality in that part. But I think at the end of the day, really what we're coming back to is, was the jury affected by this? The court polled the jury over 20 times, and I don't think that militates against our position. That supports our position. I don't think courts can be put into a no-win scenario where if they poll the jury too many times and that shows that something must be wrong. The few things the court did do here, providing security, polling the jury, the defense uses these to argue that that meant there was more prejudice. Well, if that's the case, then there really is nothing a court can do, and a high-profile defendant becomes untriable if the media attention picks up too much. And that certainly can't be the law either. If the court has no further questions, the state respectfully requests it affirms the conviction and sentence. Thank you.
Thank you, Mr. Chris.
Your Honor, first I would like to address the court asked a question about whether remedy is required for intentional and pervasive misconduct. And that's actually a holding in minute, almost word for word, the holding in minute, that intentional pervasive misconduct that affects the structural integrity of a trial requires a remedy. And not only a remedy, but a double jeopardy bar to retrial. And I would like to point out we are making a pool claim. We argued the cases regarding double jeopardy, the standard for when double jeopardy is met. And we argued the facts in our case that meet that standard, which includes the element of intentionality. Intentionality is important not only for a double jeopardy claim, but also for a due process claim. In the cases where the courts decide that there isn't misconduct, even on that end of the spectrum of misconduct, what you see the court saying is, this isn't misconduct, it was merely negligence. It was an isolated loss of temper. So they're using intentionality on either end. So it is that in as much as non-errors and harmless errors help us show that the prosecutor acted intentionally and with an indifference to the danger of causing a mistrial, those errors are counted. And so Hughes itself, the case on cumulative error, explains that you do consider intentionality. I'd also like to address the idea that we ought not assume the worst possible meaning of a particular phrase used by a prosecutor during the trial.
A particular...
A phrase or a question, or when you're looking at whether or not the prosecutor says something and is that thing really is, we have two different directions we can go with it. One of them is fairly innocent and one of them is pretty terrible. Should we assume the more innocent version or the terrible version? And my opposing counsel noted that we shouldn't assume the worst meaning. And Hughes actually stands for the fact that once you have a pattern of behavior from a particular prosecutor, you're not required to keep giving that prosecutor the benefit of the doubt. And in fact, you should assume the more problematic meaning when it fits together with the other kind of misconduct that the prosecutor is committing. And it fits together with the theory or theme that the prosecutor is building with his misconduct, which is the case here.
So if the prosecutor asks 30 times, oh, but wait, you care about the defendant, don't you? That becomes problematic?
Right, yes, even the very first time that he did it, because if it had only happened one time, you might give him the benefit of the doubt. The court might be inclined to say, well, that's just inelegant wording or a bad phrasing. But he didn't come back to it. He didn't repeat it. He didn't emphasize it in his closing argument. We didn't get any jury questions on that. all of which is the opposite of what happened here. When we're talking about Mr. Martinez accusing the witnesses of having feelings for Arias, he hit on that theme quite often.
I'm sorry, it was you have feelings for Ms. Arias.
He used feelings and I believe relationship at one point, but I would have to double check to make sure of that.
But the point is you repeat it enough times.
Right, that it is cemented in their mind, and then they ask questions about it, not only of that witness, but other witnesses. So,
And time is up.
thank you.
Thank you both for your argument. It was very informative. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.